Shari Belitz, welcome to the show. I'm so happy to have you on. And just for the listeners, I just want to talk about how we met. We've met on LinkedIn, and it's because you have the best posts on LinkedIn. You have these creative posts that incorporate a concept or a theme, and then you go and you find a song, usually an 80s song. You kind of change the lyrics around to make it funny and appropriate, and then you summarize the point you were making. And it's usually a really great point about voir dire or prosecuting your trial. So it's a pleasure to have you on.
Thank you so much for having me. And thank you for that wonderful compliment. It is so much fun to create these posts. And it's really very similar to what I do when I'm writing for trial. I'm taking something complicated, and maybe I'm not writing an 80s song, but I'm writing something interesting, simple, and attention grabbing for a jury. So it's really very much the same concept.
Yeah, it's attention grabbing, and it's fun, it's entertaining. And it's smart too, the way it's done. It's really clever.
Thank you.
So I wanted to bring you on to talk to the audience here, a lot of whom are attorneys, trial techs, because as a marketing person, I understand how market research works and how important it is to the overall product or service that you're offering. For those who don't know you, if you could explain what you do and how you got into this profession.
Sure. Okay. So sit back. It's a little bit of a story. I'll try to abbreviate it. I know we only have about an hour here. So I'm a trial consultant, and you've probably heard litigation strategist, jury consultant, all of those terms used interchangeably. I help lawyers achieve favorable outcomes at trial through jury research, mock trials, focus groups, work with them at trial, selecting juries, deciding beforehand who we want on juries, large data studies, things like that to really strategize for trial. And of course, writing and helping with openings, closing questions, things like that. That's really my jam. So that's the job. How did I get into it? Because of course, like who's ever heard of a trial consultant? Certainly I didn't back in the 80s, 90s when I was in school. So like every good story, we start with a bad date, right? So I was a freshman in college, hated my major. I was an education major, absolutely hated it. It was too vocational for me. I wanted something very theoretical. I wanted to feel like I was in college and really, learning just very theoretical things about the classics, about arts, about psychology. And I had a psychology class I loved. So anyway, one night, Thursday night, I think it was, met a guy at a bar. He was a law student. We were talking for a while. I thought he was really interesting. He asked me on a date. We went on a date that weekend, and I was grilling him because, I had seen, what was it? LA Law. It wasn't Law and Order yet. It was LA Law. And so, I thought I knew exactly what I was talking about. And I said, how does a jury not hear when a lawyer says something and a judge says disregard that or strike that? Doesn't the jury still hear it? And wouldn't it call it to their attention even more? And he said to me, you know what? I'm taking a class called Evidence, and we just learned this. So right then and there, psychology and law just intersected in my mind. I went home for Thanksgiving. I told my parents, I'm changing my major. I'm becoming a psych major. I love it. And I'm going to law school. And they were really disappointed. They thought I was going to be a teacher and have a job right away and job security and all that. And psychology and law just sort of meant unemployment for them, I think. So Anyway, that was the first time, early 90s, that these two concepts really intersected. I got to law school. Of course, it was nothing about juries and judges and witnesses. And I was so disappointed. And then many, many years later, when I was working as a lawyer and started meeting trial consultants and, using them in cases, I started to understand a little bit about the business. And I went back to grad school at night to study for forensic psychology, which is a legal psychology. So it all starts with a bad date. And guess what? This bad date lives in my neighborhood like 30 something years later. And we walk past each other and probably don't even recognize each other.
That's funny. So with this intersection of psychology and law, which I find is fascinating, how do you apply that when you have a trial coming up? How does that, when the attorney comes to you and says, Shari, I have this case, how can we find a way to message better to the jury using psychology?
So really good question. So many different ways, because I get called in at so many different junctures. I've had people call me, hey, can you, take the train to the Bronx and pick a jury in 2 days? And then I've had calls sometimes a year in advance to work on the trial. And those are, of course, my favorite calls, because then we have a lot of preparation time. We can really do a lot. So let's say someone calls me, it's really more like maybe 5 months before, and we can set something up for a mock trial, a large data study, a focus group. And that really is the research. That's jury research. When you hear someone say jury research, that is your jury research. You are going to get a barometer on what average people, regular people in that jurisdiction think about your case. And you're going to get, I always say for mocks and focus groups, don't pay too much attention to those verdicts. We want to pay attention to why the verdicts are what they are. What is the decision-making process? What are the underpinnings? What are the themes behind those verdicts? Because when you're talking about a mock or a focus group, those aren't statistically sound sample sizes. Large data studies, which I've been doing more of, those are over 100 jurors. You can pay more attention to those verdicts. But anyway, so I come in, that's the pretrial research that many attorneys are looking for. Different reasons. Some want to know really verdict. Some want to know about one specific issue that they can't tell which way it's going to go. They want to know what jurors think about it. Some want information about themes, and that really is one of my specialties. I can almost always catch a theme in a mock. I don't think I've ever not caught a theme and some sub-themes, but I can often catch them as early as the intake call. So those are the mocks. That's the pretrial research. Then I will often come in, as I'm doing on a few cases now, working to simplify, working to write voir dire questions, working on attitudinal jury profiles, which is who we want, who don't we want, and what questions are going to tell us who we want and who we don't want.
What's the difference between a mock trial and a focus group? And is it a function of pricing, or are there certain areas where it's more helpful to do one over the other?
So that's a really good question, and that comes up a lot. And actually, the terms mock trial and focus group are often used interchangeably. They are not the same thing, at least the way that I do them. They are not the same thing. Mock trials are generally done when discovery is closed or towards the end of discovery, and they are an adversarial type of exercise. There will be the same firm will have let's just keep this really simple. Plaintiff's attorney, defense attorney. Sometimes there are a few more parties, but let's just say plaintiff's attorney, defense attorney, and they will be giving persuasive arguments that are really a combination of an opening and closing. The mock jurors get to see evidence. They deliberate on a verdict sheet. They deliberate as groups. They fill out individual verdict sheets. It's a lot more like a trial simulation. A focus group, on the other hand, I've even done these pre-suit before a suit is filed. They could be done early. They could be done in the middle, or I actually also do them after mock trial. So let me explain that. A focus group is really convening a group of people and trying to understand their attitudes about some basic things, some general things, but then also really narrowing down to case issues. So that's something that I lead, that I moderate. I'll write the script for that, and it's really getting their barometer on issues. That being said, after every mock trial, once the jurors are finished deliberating on their verdict sheets, then I run a focus group because, again, that's moderated discussions. The jurors are then why'd to death. I call it death by why, and they're asked about their decision-making process. They're asked what they think about different pieces of evidence, witnesses, things that they've seen, things that they've heard, what's most persuasive, really just all types of questions. And sometimes if it's about a specific hot button issue, they're asked general questions about that issue as well.
So what are some of the types of biases that you look for to either use, identify, exploit, mitigate, but use for the purposes of analysis going forward?
So cognitive biases, for the audience, those are mental shortcuts. We'll sometimes call them heuristics in the psychology world. And that's the brain's way of being lazy and not actually doing the work and just sort of making that knee-jerk judgment about something. And there's many different kinds of biases. We all have many different kinds of biases. So one that I'd like to talk about, because I work for the civil defense side, 99.9% of the time. The other percentage would be like a commercial case where it doesn't matter which side I work for. But I work for the civil defense side in personal injury cases. And one of the biases that work against us is the availability bias. So that is one that I'm going to try to mitigate, but the plaintiff is going to try to exploit. So, for example, the availability bias is relying on a piece of information that comes to mind quickly. So, for example, so we sit here in January 2025. There were recently 2 airplane crashes that both have been in the news quite frequently. They were quite sad, very tragic. And people are really focused on it. And I've heard people say, like, oh, don't you have to do air travel at some point soon? Like, how do you feel about that? Do you want to do that? Meanwhile, I picked up the paper this morning in a little blurb. There's been like quite a few tragic car accidents in my area. You don't see it blasted all over the internet, blasted all over the news. So availability bias, you're not really paying attention to statistics. You're getting more, and cognitive biases are emotionally based. Those are your emotions really taking hold. So where someone may be afraid to take an airplane, they'll think nothing of getting in a car. But if you really look at the statistics, that is where you're more likely to have an accident or to have something catastrophic happen, to have a death. So it's up to the plaintiff is going to exploit that, because the plaintiff is going to use emotion and they want to use that availability bias to show that there were systemic problems or there is a danger to everyone, and really kind of scare and anger jurors into being concerned. So they're exploiting availability bias. It's up to defense to minimize availability bias and do that with data, do that with statistics, and really show that that's not always the most glamorous, interesting thing for a jury to see. So we have to make it understandable. We're not going to make it fun, but we have to make it understandable. We have to grab their attention. We have to have them use that cognitive cerebral cortex part of the brain instead of that more emotional amygdala response to really think about things in a way that are going to defeat availability bias. So that's one example of a bias.
Yeah, I think that's I think it's so interesting. So this question is a little bit more. It's a little longer, but it incorporates some of my experiences, because I was in a jury one time, and so I was on a jury. It was a district court jury up in Massachusetts, and we heard the evidence, went back to the deliberation room, and there was one guy who was an older guy, and he said, "I'm going to vote to acquit, and there's nothing anybody can say that's going to change my mind." And he folded his arms and he leaned back. And that act really influenced how the jury approached the case, discussing the case and the outcome. Now, looking back, he was probably right in that case, but he had undue influence over the other, and he didn't want to discuss it in a rational way, or in the process that was laid out. In contrast, I was at a focus group one time, and this was a focus group for a trial that was coming up. And I was in the back room looking at the closed circuit TV, and I saw this woman on the jury or in this focus group, and she had been a boss. She'd been my boss like a few years earlier at a job. And I said, "Oh, this person, she's got a strong personality. She's really going to, she's really going to rule here. She's going to dictate the conversation." And she melted into the wall like a wallflower.
Wow.
And I thought, that is so interesting. So my question, based on those little stories, is is there a way to identify if somebody's going to be an influencer in the jury, rather than just approach it from, this person has this bias or this bias? We all kind of have opinions going in, but what makes somebody influential?
So that's a really interesting question. And I am lucky because I'm a fly on the wall at all these mocks, so I can kind of see, who I think is influential. Are they really influential, and what factors, at least anecdotally? So using social science, but also using some anecdotes, leaders. There's going to be high status leaders. That is usually someone who manages in a job, someone who is in charge of people, someone who is, I almost always find anyone who is in the military or who served in the military is almost always a leader in that group. So certain things like that. I had a CEO in a recent mock trial, and he absolutely led his deliberation group because, of course, he did. He was a CEO of a medium-sized company. So things like that, as far as managerial skills, there's also that sort of intangible, the charisma. Are they good looking? And I'm not saying like model, actor, actress, good looking, but well put together, sort of have it together. Do they speak well? Are they articulate? And you can tell in jury selection with a real jury, are people paying attention when they speak? So there's those factors. Then there are what I call the stealth factors. And these are the factors you really want to watch out for because they can bite. So these are jurors who have information about the subject matter of a case. They normally wouldn't be a leader, but because they have certain subject matter experience or knowledge, they are in fact a leader. And this is not information that's necessarily going to come out in voir dire or on their questionnaires, or maybe it does and they get selected anyway. So for example, let's say you have a construction case and it's very technical and it's about constructing a building and maybe there was a defect, and you have a bunch of very highly educated people on the jury. Maybe you have some professors with like gazillion grad degrees and people who are very highly educated who might normally be leaders. But then you have someone, high school grad, who worked in construction, maybe doesn't work in construction now, so didn't answer about that, but worked in construction during the summers for family business, something like that, who has a lot of case specific, or not case specific, but industry specific knowledge about how things work. That person may end up being that de facto stealth leader. We all remember the Ghislaine Maxwell trial from several years ago. There was someone in the jury. There were questions written to screen this out. Apparently that person missed the questions, but they were abused as a child, and they may not have appeared as a leader. I think they appeared very quiet. But when it came time to talking about subjects like memory and abuse and things like that, that person emerged as the leader. So those are the de facto stealth leaders. But most of the time, we're going to be able to pick out those high status managerial, sometimes you'll get doctors on a case. They will often lead military. They will often lead, anyone with really a charisma that you can kind of pick up during jury selection, they are going to lead. So that's how you look for the leaders.
That's interesting. Yeah. I was just thinking of this case I had read about where somebody who must have been a leader said during a criminal trial, this murder trial, and I think it was England, they said, why don't we have a seance to see exactly what happened? So the jury went and had a seance, and that's how one of the reasons they arrived at the decision that they did. Of course, it was thrown out, but people just do some crazy things too.
I've seen some crazy things in mocks, and the scary thing is we don't know the crazy things that happen in a deliberation room in a real trial, but I get to be that fly on the wall and see the crazy things that happen in mocks.
That's fine. Yeah. So, all right. So you've got the mock trial data or the focus group data. What's the next step in the process? When you've got this information, you go to the attorney or the law firm or the legal team, you say, here you go. Here's my report.
So the first step is I'll actually look at the data the night after a mock and just kind of get that organized, take a once over. And then from that, I start to look for patterns. I start to look for themes. I'll probably have already caught a theme during the mock, and I will see what the data supports. And I will start to write my report. My reports are very practical. They're very thematic. Like they are basically roadmaps for if you're going to trial soon, it's geared to be your roadmap to trial. I'll make all sorts of suggestions based on what the data shows and the theme that I extrapolate. If it's going to mediation or the trial date's not for a while, or, counsel really is posturing for settlement, I will structure the report like that. And it's still thematic, but it's really more evaluative as far as where they want to go for settlement. So it's very customized to what the goal is.
So I think everybody or the listeners have an idea, but how would you define a theme? What's a theme, and how to in this context?
So it's interesting you ask that question, because a lot of people use case theory and case theme interchangeably, and they're not the same thing. So your case theory is going to be, that's a legal theory. Like your theory will be negligence, or maybe like our theory will be comparative negligence if we're the defense. A theme is more something to use to communicate with your jury. It's like a universal human condition that's understandable and really sums up what the case is about. You should be able to say this case is about. So I like using themes to often shift the focus. I use themes to simplify, but I'm going to use a theme because that's where I want the jury to focus. So for example, several years ago, I had a case, negligent security case. A woman was assaulted in a building, sued the landlords, and the case was made about a broken lock. Plaintiff's theme had to do with a broken lock in the building. The person who came in and assaulted the woman had been on probation just a few days, was a sex offender, serial sex offender. So I wanted to shift the focus and make the case about this violent third-party actor. Like, let's all hate on the actual perpetrator and not the landlords, who are really, let's put the landlords in the same boat as the plaintiff. No one wants a perpetrator coming into the building and assaulting anyone, and the landlords happen to live in the building. So this made the theme easier. So the theme that I wrote for that case is, this is not a case about broken locks. It's about broken justice systems. And shifted the focus to the broken justice system. Here's a guy out of prison, few days, and what does he do? Again, assault someone right away. So I have a lot of auto cases where the impact to the car may not be a lot. If we represent the trucking company, the impact may be light. The people in the car may have walked away. Plaintiff may have walked away right after, been fine, not sought medical attention, but their first stop is to a lawyer. So a theme for a case like that, and I see it over and over again, is they were putting wealth before health. And I like to make my themes rhyme. I like to make them alliterative. I like to make them really sum up what the case is about, but also be memorable, because the theme will assist in memory. And if the theme is that good, all of the evidence will get filtered through the lens of that theme. And that's what you want.
In your mock trials or your focus groups, do you ever use media or imagery? Does that play a big part or a small part in how you approach your mock trials?
Absolutely. And sometimes that imagery is really something that can help demonstrate the theme. So take, for example, a case that's very visual. I had an auto case long time ago. It's long since disposed of. And what you could tell from looking at the photos is every witness on plaintiff's side had some sort of obstruction to their view, and you were able to tell this from the imagery. Every witness who testified for the defense did not have obstruction. You could tell that they had the better view. So the theme I wrote for that was the vantage advantage. Who had the better vantage point to see what happened? And you could tell all the defense witnesses did. So that's one situation where imagery was very powerful. Then you can use it in cases where there's maybe a lot of parties or complicated business transactions. You can really graph things out and make them make sense to a jury. They can really help simplify a case. Name boards, maps. I like animations for accident cases, dosing in toxic tort cases, different demonstratives to show timing when timing is an issue. Yeah, absolutely useful. I often recommend a graphic or an animation or a demonstrative in one of my reports. I don't actually put them together. You would not want me to put them together. That is my not my superpower, but I will make a recommendation, and whoever does have that superpower can execute on that.
Do you ever hear from the jurors after, for example, we have these post-trial jury interviews and things like that. Do you ever have post-mock trial interviews with jurors where they talk about the visuals, how much they made an impact, or do you get that data during the process?
So, interesting question. For mock trials, we do talk to them because we do that in the focus group. So they'll tell us. And one of my questions is always, what holes were there in the story? What would you like to see more of? What would be helpful? And we often get responses about, well, I'd really like to see a map of the accident, or I'd really like to see a video of the fall, or I'd really like to see, and they're asking for something visual. In real trials, we talk to jurors as well and see what was persuasive. Really the same questions. I don't love talking to, this is sort of contrary to a lot of views. I don't love talking to jurors after a win. I'm always afraid someone is going to say something that could put that in jeopardy. So I am paranoid about that and will only do it if counsel wants to do it and asks me to do it. But you do learn a lot from that postmortem. But in mocks, they're telling you everything because you're asking them everything. So they'll tell you what visuals. Oh, we needed a timeline. We got confused about the parties. We weren't sure which company did what. So visuals are very helpful. You'll find that out in any kind of postmortem, whether it's a trial or whether it's a mock trial.
So we hear a lot about demographics these days in politics and in jury research and things like that. But are we really talking about psychographics, or what's the difference between a demographic or our understanding of a demographic and psychographics, and how do you see? I guess it's another question. How do you see that shifting lately?
So demographics, to define for your audience, that would be age, gender, income, education, occupation, family structure, married, divorced, kids, no kids, that type of thing. Psychographics are more like psychological and cognitive data about a population, like their attitudes, their values, their interests, their personality, things like that. So with demographics, there are certain demographics which you absolutely cannot make decisions about in voir dire, and that's the Batson case and its progeny, race, gender, certain demographic categories. However, it's important to note that, like, even if Batson didn't exist, even if we could do that, demographics don't decide cases. Attitudes, values, worldviews decide cases. Experience doesn't even decide cases. People can have identical experiences, but have a different attitude about that experience. And I always give the very simple example. My sister and I both grew up in New Jersey, same household, same parents, same everything, because we were in New Jersey in the 80s. She hates malls. She absolutely hates malls. That's her attitude about malls. Me, love them. Love them. So we've had the same experience, but we have a completely different attitude about that experience. You could take 10 of me, my demographics to a T, and we can all feel very differently about PTSD, an issue in a case. So again, we have to get beyond demographics. We have to get beyond experiences, and we really have to explore attitudes and personalities to the issues in a case.
With certain changes, cultural changes and sociological changes that are inevitable, that the changes happen in the jury pool too. And I've heard this concept called safetyism. Mm-hmm. How do you define safetyism these days?
So it's really interesting, Tim. I've seen, not lately, but maybe last year, I've seen a lot of people writing on LinkedIn about safetyism and giving all sorts of seminars and like making it kind of the new scare tactic, sort of like the new reptile. And it's not that at all. And to give you the background about safetyism is I think it was about 2015. So we're talking like quite a while ago. A psychologist named Jonathan Haidt, and we've heard about him as of late because he wrote The Anxious Generation. I know a lot of parents are reading that book about, kids and smartphones and, TikTok and, glued to their screens and everything like that. But Jonathan Haidt and another psychologist, Greg Lukianoff, they wrote an article in The Atlantic, and it was called The Coddling of the American Mind. And the premise was that it was a student-driven movement, and it was attempting to scrub campuses of words, ideas, subjects that might cause discomfort, that might cause offense, that might cause these college students to be triggered. And they opine that this emotional reasoning and protectionism interfered with the students' critical thinking, actually, and it fueled like an anxiety, which they coined the word safetyism, where people prioritized safety at all costs. And so anyway, they wrote a book about this a few years later called The Coddling of the American Mind. And they discuss a couple of ideas in The Coddling of the American Mind. And these ideas, the underpinnings of safetyism, are what doesn't kill you makes you weaker. Always trust your feelings. See, here we are going to the amygdala, not too different than the reptile. And life's a battle between good and evil people, like a very binary, not nuanced at all way of thought. So anyway, this is really, I think this was a politically motivated article and book, but lawyers and others in our legal space have taken it and extrapolated it to juries and kind of came up with this safetyism that there are going to be jurors, I call them perfectionist jurors, that are going to expect that everything is 100% safe. And where have we heard this? We've heard this in reptile, and tort standard is not the safest. Tort standard is reasonable care. So anyway, I think that this is, I could see what Jonathan Haidt and Greg Lukianoff were doing. I think it was more of a political statement, and it was really kind of taken to a new level, and I hear and see people speaking about it. So, it started as a discussion of free speech and polarization and things like that. And it's kind of raised the question about, is this causing jury verdicts to rise? So that's safetyism. And, the questions are, if this is true, well, how do we elicit these attitudes from our jurors? Like, how do we know if they're safetiest jurors? Like, how do we know, how do we use our witnesses to balance this phenomenon? How are there thematic ways to frame a case? I have some other questions about safetyism. I actually think this was political. I think this was a political article and was just interpreted or misinterpreted to give a different type of spin to it.
I know that there are some very large plaintiff verdicts that have been the trend lately, it seems. And I think you said in somewhere that you'd asked one of your colleagues, why did these plaintiffs get such large verdicts? And you remember your response?
They asked for it.
Yeah.
Very powerful. The most powerful rule of anchoring. And I see it in mocks all the time. Why did they get $50 million? They asked for it. And I'm actually working on a white paper now, which is a little more nerdy than my usual repertoire of 80s music. But it's because I've worked recently on several large data studies, and just some information spontaneously came from these studies. In a couple of them, we tried first of all, we have a statistically sound sample size of 100 plus jurors. So we're not talking about a mock, we're talking about stats. And what we found is when we used a combination of different plaintiffs' anchors, different conditions, different defense anchors, no plaintiff's anchor, no defense anchor. But when you use that plaintiff's anchor and don't have a defense anchor, that's all the jury has to go for. Why did they give a $50 million verdict? Because plaintiff asked for it. And that's all they have. And that's all they know to look towards. And so we'll have this white paper coming out soon about our findings. And again, no Bon Jovi or anything, but it is very interesting.
That's interesting. And nothing bad about Bon Jovi.
Nothing.
Now, I was just thinking that when we were talking earlier, my son, I was listening to some older music, and he said, Dad, you like that kind of music because you were born in the 1900s. and then the Guardians of the Galaxy came out. It's like, listening to the soundtrack, I guess the stuff is pretty good. So
that is fun. I have to say, I was helping my daughter. She's 14. I have 14-year-old twins. I was helping her with some homework the other day, and I like to, when I'm helping, I can't look at the computer. I need something printed. So I asked her to print me the outline she was looking at. And she just looked at me like I was crazy. Why would you want to print something?
That's
and I'm like, why wouldn't you want to print something? I print everything. When I proofread them, I print. And
I find it easier to read. There's just something about that tactile experience of reading a book or even a report or something. So, but it's a new generation.
Well, look how full circle that goes to visuals and demonstratives and things like that. And even in the sales world, think about it. So you're going to buy, or maybe I'm going to buy a necklace, what is a good salesperson going to do? They're going to let me try it on. They're going to let me touch it, like that tactile. When you go to buy a car, you're not just looking at a car. They're going to let you drive it and let you have the experience. And it's not really that different with a jury, like with showing them something or letting them, if they're in a jurisdiction where you could take notes, you want that theme to go into their notes because their notes are going into the deliberation room. So back to your point. So I'm going to tell my daughter that we need to start printing out our stuff on ancient Greece and Alexander the Great. We'll retain it better.
Or just write it on tablets.
Absolutely. Something that you can hold.
Like immersive learning there.
Absolutely. I'm going to tell her that tonight.
Well, so I find this fascinating. Is there anything that you would like to promote, something that's important to you, or where can people find you?
So, okay, that kind of dovetails nicely because people can find me on LinkedIn always, all the time, screens always up, phones always open. You could find me on LinkedIn. So what do I want to promote? Actually, my method, my mantra, my everything is I will never promote a product. I will always give information. I will almost always make it fun or make it intriguing, which is what I try to do every day on LinkedIn. So rather than promoting a product or say, come on, like hit me up for a mock trial or large data report, I'm going to say, read my 80s content and see what you can learn and ask me questions and see if this is something that you want to talk about further, because I really believe, and it's kind of funny because again, full circle, I said, I hated that teaching school and didn't want to be a teacher. I find it is so fulfilling to actually just teach something that I'm passionate about. And if someone, and there have been people that told me like, we can't afford a trial consultant, or my carrier, doesn't have it in their budget, but I took your posts and I put them together and, I used them for a trial, and that's amazing. And then there'll be times, I'll get calls like, oh, you're the reptile girl. Can you help me prepare a witness for a deposition? So, so I don't want to promote anything specifically, but would love to get to know you to get to know me. LinkedIn's the best place to do that. You could also, of course, go to my website, sharibelitz.com. I have a bunch of free ebooks on dangerous documents, voir dire, all sorts of things that may be of use. And then I have a subscription course in Psych Lawpedia, applying psych to the law. And again, not promoting anything, not infomercial, just information. And that's pretty fulfilling to be able to have good conversations about that and teach people about what I'm passionate about.
Well, thank you so much. I am so happy that you agreed to come on the podcast and have this conversation. And it's been a lot of fun and really informative. And so thank you, Shari Belitz.
Thanks so much for having me. Have a great day.